What comes to mind how you could have problems with joint titling a non-spouse situation?
Well, first of all, I think it's important to understand there's really two ways you can typically hold real estate with multiple owners, either in joint tenancy, which typically means by right of survivorship, meaning, for example, Paul, if you and I own property, as you know, and it's jointly titled, and I die, you get 100% of it and vice versa. So it's sort of the he who dies first loses. The other side of this is tenants in common, and that's the assumption at law, if it's not specified, that that's how it's held. So, for example, a lot of people will have a property owned by themselves, their wife, their cousin, their brother, and whomever. And what they don't understand is those are divisible interests if it's not set up correctly. And what I mean by that is if one of them dies, now we have a probate problem. That piece of the property is now locked in court and can't be freed until that estate is probated. And again, as each person dies, you have another probate situation. So I deal with situations all the time where somebody comes to me and they say, I've got this property that I think I inherited from my mom. It's got my 3 uncles, my cousin, whomever, and they're all dead. And I say, well, get out your checkbook because we're going to have to open up 5 or 6 probate estates and go through this whole lengthy court process.
I mean, in this discussion, probate is kind of a bad word here, right? I mean, this is what we're trying to avoid because probate is typically going to cost more attorney fees, court fees, time, right? You can't sell your interest while it's in probate. These are always issues.
Assets are tied up. There's probate fees, court costs, attorney's fees. And I think at the heart of this, Paul, it really comes down to when somebody is sitting down trying to figure out long range what they want to do with that real estate. That's where somebody like me comes in handy because I can sit down and go, okay, what is your master plan with this real estate? And let's set it up correctly now so that your wishes are adhered to. Because again, I find a lot of times people, their desire is that he who dies first, in fact, does forfeit their interest to the other party. A lot of times when I tell clients that's how it's set up, they look at me funny and they say, well, wait a minute. So if I die, this all of it goes to my brother, not my kids? Right. So they really need to understand what they're trying to do and get it done correctly.
And this could be a vacation home. This could be investment properties. A lot of times people pool some money together to do some investments together, and it really matters because, frankly, if the 3 of us, Ron, Paul, and Tina, were to do something with some investments, and God forbid I die first, I don't want you to die either. Well, anyway, the point is, I, of course, would want my interest to go to my wife, not you.
Correct.
And we can set it up that way.
Right.
If we decide to, this isn't impossible to win this war. You can talk to the right people. Ron Thompson with Thompson, Stewart, PC is that sort of person who can help you. So problems with tenants in common in particular, what comes to your mind? These are your notes I'm looking at.
I alluded to the biggest problem, which is most people, they don't understand if they have it set up that way and somebody dies, it's going to automatically go into probate unless they've got that somehow set up into their trust. So that's the first problem. The other issue is with tenants in common is a lot of times I see those in vacation or investment properties, and there's issues that can't be resolved through the title. For example, three individuals own an investment property, and they've got this verbal agreement that they're all going to share in the taxes, expenses, et cetera. Well, all of a sudden, one of the guys stops paying. Well, then what?
Yeah.
So again, there's ways to fix that. On that issue, what I typically like to do is set up, again, a limited liability company with an operating agreement, and the operating agreement specifically says, here's how all these issues are going to be handled, and here's more importantly how we're going to deal with it if somebody doesn't do what they're supposed to do. And by the way, if somebody dies, here's now specifically how it goes. For example, some people will say, well, Ron, I don't want to get into probate, but I also don't want to be jointly titled because I don't want my interest to go to my partners. Well, then we set up an LLC, and the operating agreement talks about that. And because it's in an LLC, the LLC can then transfer that interest to that person's heirs without probate.
Yeah, so there are ways to do this. If you're sitting with the right people, a dream team of experts is what we bring to you every week here on Michigan Real Talk. People who look, I'm not good at everything. I don't know what he knows about titling. He's a real estate attorney. I'm a great real estate broker.
Right.
But you need to talk to an attorney when you get into these issues, especially when there's investments in LLCs and all of these things. This is beyond my scope of expertise. It's the same way you need a plumber when you have those problems. You don't need me helping you with that either. That goes bad, it goes real bad.